Hello and welcome back to the Data Privacy Lawyer. It's Funmi, the principal attorney speaking. Today's review is going to be looking at some AI terms. So we're going to quickly take a look at the products here. We can see the cookie banners appeared. That's really good. I'm just going to reject all. Let's take a look at their solutions because the solutions and products influence the terms and conditions for the AI. So it's an AI-powered platform to manage policy issues. EU policy tracking solutions. Interesting. Okay, so it looks like it's something to do with like maybe government related. Let's look at solutions. Okay, so policy management, market intelligence. This is interesting. I'm interested in what type of intelligence is being provided to the market, but it looks like it's government related. And it looks like some of the customers they have are going to be like government agencies. So I want to talk a little bit about what type of privacy legislation may apply. If FiscalNote is providing a service to a government agency, there may be additional privacy legislation that applies that may not apply to the public sector. There is a very specific act in the federal space called the Privacy Act of 1974, and it generally dictates how personal data can be processed in the federal space. Let's see if it's acknowledged in the AI terms, but it looks like some of the customers associated with FiscalNote may be government agencies, and that will influence the type of processing of personal data that may be uploaded to this solution. So it's another software as a service tool. Let's have a look. From time to time, provider may introduce features and capabilities that utilize AI, machine learning, or similar technology. Customer may upload information, including customer data and user content, and receive output generated by AI features based on the input. Customer is solely responsible for the input and for ensuring that the AI content complies with applicable laws, these AI terms in the agreement. Now, this is a really important sentence because applicable laws include the personal data laws, right? There's a lot more legislation that goes into how artificial intelligence is conducted outside of personal data. But because we're a privacy law firm, we look at the privacy implications of using artificial intelligence. Those implications would be if this provider is going to process personal data on behalf of another customer, let's say, for example, a government agency, the specific rules they need to follow, like providing notice to the end users, obtaining consent where necessary if required by law. There's lots of different things that are being asked for here, but essentially what the service provider is saying is that the customer has to ensure that it meets its own compliance with applicable laws. So if the customer is obtaining data, it needs to make sure it follows specific rules before it puts that information into the SaaS solution that's being provided by FiscalNote. So if you're going to be signing up for their AI, you need to make sure you've already done your own compliance. I think this is really valuable because it also puts the burden of privacy compliance on the customer too. If you're signing up and saying, I'm going to use FiscalNote, it means that you've already met your own privacy obligations. Depending on how you're going to use the tool, there's a lot that goes into that, but I think it's really important for businesses to understand that if you're going to sign up for this, it means you're complying with the applicable laws. Now, are you? You need to take a look at your privacy program and make sure that you are before you sign up for this type of solution. Provider may use aggregated de-identified customer data across its products to train and enhance its artificial intelligence and machine learning models. Provider will ensure no personal data can be isolated or exposed in this process. Now, I am interested in this sentence a lot because there is no discussion on how this provider is obtaining the aggregated data. Is it that they are conducting a processing activity that allows them to aggregate personal data? The other thing I want to mention is this word, de-identified. In what manner and what is your process? That would be my question, essentially. What does de-identified look like to this organization? Because in the data protection space, there's something called anonymized data and pseudonymized data. Depending on what this de-identified process looks like, it may be that this still constitutes personal data depending on the process. The first question I would have is, what is the process that is being used to de-identify the customer data? Does this customer data contain personal data? First question. Second question, what is your process for de-identifying? Because if the de-identification process makes the data that is created pseudonymized data, it still constitutes personal data. So there needs to be internal documentation by this organization on what de-identification looks like to them. And the customer should be cognizant of this because essentially what they're saying is they could potentially use personal data to train and enhance their AI solution. Is this something that the customer is okay with from a risk perspective? It seems like they also sell their products in the European Union. Now, this is really important. I've talked a lot about geography in the past, but essentially geography influences what a business has obligations to do when it comes to personal data. In the European Union, there is data protection legislation called the GDPR. The GDPR is comprehensive privacy legislation that applies and has very specific thresholds. If a service provider like FiscalNote is going to be processing personal data in this geography, it has different obligations than in the United States because the laws are different. And that's something that businesses should be cognizant of. You've agreed, let's go back to this. The customer is agreeing that they are responsible for the input and ensuring that the AI content complies with applicable laws. You as the customer need to know which laws apply to you. If you're an EU customer, or let's say you're a US customer, but you also process EU data, you're agreeing to in these terms that you've already met your obligations under the applicable law, which from a privacy perspective is the GDPR. So each sentence ties hand in hand. That's what I see here. And if I was giving advice to a client, I would be like, make sure that you understand that this is what is applicable to you. You're signing up for their tool. You're saying that you already comply with the applicable laws, but you process EU data. Do you have in place all of the mechanisms required under the GDPR before you sign up to this? Because if you don't, then you're technically in breach of these terms, right? EU AI restrictions. Customer will not, unless permitted by express written consent from the provider, use provider data, AI features, content or output in a manner that violates applicable laws, which is the GDPR, regulations or guidelines, including but not limited to the EU AI Act. Let's talk about transparency. This is a very popular privacy foundation that looks at being transparent about your different privacy practices. I would presume that there's going to be some type of personal data in scope because at a minimum, users are going to need to be able to log into the SaaS solution. That's why I think it's really important to review the products and services that a business has because it influences the type of legal advisory you'd get from a privacy lawyer on what your obligations are. And there's going to be different components and different types of privacy laws that apply to your products and services and the requirements on what makes you transparent under the data protection laws. The provider shall ensure, so this is the responsibility of FiscalNote, AI features designed, developed, and deployed in a manner that's transparent, traceable, and auditable, implements appropriate data governance measures to ensure the accuracy, relevance, and proportionality of the AI feature, and conducts regular risk assessments to identify and mitigate potential risk. Let's talk about this. I think that the risk assessments that are being discussed in this sentence also include something called a data protection impact assessment. Now that's very privacy specific and is not exclusive to artificial intelligence. But depending on the level of risk associated with the personal data that will be uploaded into the SaaS solution, it's really important for not just the provider, but also the customer to really look at, are the rights and freedoms of the users in using this product going to be hindered? In that instance, conduct a data protection impact assessment. Those data protection impact assessments allow you to mitigate potential risks, so it's really important. Let's take a look at the AI input and AI output. AI features and AI input and AI output are deployed in a manner that's transparent, traceable, and auditable. Let's talk about what this means from a traceable perspective. If you process personal data, whether it's in a controller respect or in a processor respect, you may have obligations under the data protection laws to fulfill something called a data subject request. A data subject request is basically where an individual can reach out to you as a business and they can say, hey, I want you to fulfill my right to access, delete, restrict. There's lots of different rights that are associated with an individual when you process their personal data. It's really important for AI inputs and outputs to be traceable, because if a data subject ever wanted to fulfill rights that they have under the applicable data protection law, you need to be able to trace where their data has gone in and out of. One thing I think is really valuable for businesses to create is something called a data flow diagram. It basically helps you review where the data originates from, how it's used, and then where it eventually ends, because that's going to allow you to trace the data in the event that you do receive something called a data subject request. So it looks like that's the end for these AI terms and conditions. I presume that these are going to be read in conjunction with any other agreement that is in place. Generally, this will include something called a data processing agreement, which is what data privacy lawyers will draft and negotiate. But I really hope you enjoyed this particular review. If you have any comments about my review, leave a comment below and I'll see you in another one.